Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open. 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts, back on the air. How you doing? Well, listen, I always appreciate the fact that you're listening to me, and whether you're jogging right now, just laying around, the pool, or, taking your favorite stroll for your morning exercise, I do always appreciate it. I really do. Now, look, the topic today I'll get to in a second, but it's going to be on the golden rule of employment relations. But I got an email that I wanted to address first. I got an email from an inquiring supervisor who wants to know whether or not the employer has to pay employees for using their personal cell phones for business. Now, look, I'm a little confused by that, but I guess I understand. I mean, I'm not confused at the question. This has actually been around since 2014. So the easy answer to the question is yes. Employers have an obligation. This is California only, so this is not for my national listeners. You have to pay employees for using their personal cell phones for business. Now, back in August of 2014, the California Court of Appeals ruled in a particular case that employers are required to reimburse employees for all business-related calls made or received on an employee's personal cell phone. Now, the court specifically stated in that holding, we hold that when employees must use their personal cell phones for work-related calls, Labor Code Section 2802 requires the employer to reimburse them. Whether the employees have cell phone plans with unlimited minutes or limited minutes, the reimbursement owed is a reasonable percentage of their cell phone bills. Now look, keep it simple. Yes, you have to do it. The question that always comes up is, well, wait a minute. How do we figure out? Because nobody wants to do a reconciliation every month to determine the time. Here's what you do. You ask the employee to bring in their cell phone bill for the last 3 months. Now, you take that bill, those 3 bills, you get the average of their bill. And let's just say the average of their bill, for easy math is $100. All right? So each month is averaged out that their bill is $100. Okay. A reasonable negotiated amount that I've been talking to clients about is roughly 25%. So 25% of their $100 a month average bill is $25. So what you have to do is give the employee $25 a month and just be done with it at that point. You don't have to recalculate it every time. Now, you could once a year go back and do an audit and look at it and say, okay, what's the last 3 months, and see if it's pretty consistent. Now, 25%, in my opinion, is reasonable. I'm not seeing anything on any particular figures, but as I just told you, the court said, a reasonable amount. So negotiate with the employees. Some employers do not want to get into the expense of providing people with cell phones. It's business related. Here's a cell phone. I provide my people with cell phones, and I don't know whether that's easier or not easier, whatever the case may be. Some of them carry 2 cell phones, so it's even something that we've looked at recently to find out whether or not it makes sense to continue in that, as opposed to maybe just giving them the 25%. So the main thing is make sure that you negotiate. Whatever you negotiate, put in writing, because you know me. Always put it in writing, have them sign off on it, and then you'll be good to go. All right? You have any questions about that? Joe sent this in from an email. Joe, if you have any further questions, send me another email, and I'll talk to you more directly on that. But for right now, you have got to definitely reimburse employees for their cell phone use. California just passed a new law about reimbursements in general that's now enforceable by the California Labor Code. So now you have no choice, because the labor board, before, is what would happen with the reimbursement, they had to go into Superior Court. The employee had to go to Superior Court, small claims court. Now the cell phone reimbursements can be done through the labor board. So you don't want to end up in front of the labor board. All right? So make sure that you take care of that. Now let's get into the golden rule of employment relations. Now, the issues to me about employment relations and the golden rule, when I do my seminars, there's 3 words I always tell my managers. And I know my managers out there that are going to be listening to me, and they're going to laugh when I give you these 3 words. But the 3 words I always tell employers / managers and supervisors are fair, firm, consistent. You want to be fair with your policies, you want to be firm with your policies, and you want to be consistent with your policies. If you are not fair, firm, and consistent, I'm telling you, you're going to have some issues. This business about the golden rule of employment relations, different people will give you different points of view on that, I'm sure. I would just like to cover a few things, and hopefully these things will work for you. Now, fairness. Employees are always going to say you're not being fair. Look, if you are being fair, don't let that word trip you up. Fairness. From whose perspective? From an employee's perspective, it may not always seem fair. From the employer's perspective, it's always going to seem fair. Because what you don't want to do is show favoritism and things of that nature. You treat everybody the same way. You'll have less issues with discrimination claims as well when you treat everybody the same way and when you're trying to be fair. Now, let's talk about some issues that we see. Appearance. Does an employment action appear to be fair to an outside observer? You always need to look at whatever action you take. What would happen if somebody else was looking back into that situation? Looking back into it, would they be able to say, I would have done it the same way? That's why you leave out your personal feelings. You need to be totally objective and not subjective in the actions that you take. Look at it this way. I can tell you, as a former police officer, when we were writing reports, we always wrote those reports knowing that there's a possibility that these could go in front of a jury at some point, in front of a judge at some point. The criminal defense attorney could look at it. So they're always written from an objective standpoint for all practical purposes. Now, counseling. Except in the most egregious of cases, was the employee told of a deficiency and given a chance to correct it? Look, that to me, you have to understand about this thing about documentation. Documentation is the key to success with fighting off claims. Now look, it's not bulletproof, all right? It doesn't make an employer bulletproof, because somebody's always going to argue about the warning notices. But I can tell you that there's plaintiff attorneys out there that have stated that when a client walks through their door, one of the first things that they ask them if they start talking about wrongful termination, they'll ask them, were you ever warned in writing regarding your behavior? If the client that walked through the door states, yes, they had, the plaintiff attorneys know in their minds that their case has been diminished somewhat because of that written warning. Yes, they will look at other things to try to argue about the written warning and the whole 9 yards. But why do they say that? They say that because there's an expectation with a jury. Who's sitting in a jury box? It's normally not managers. They're too busy for jury duty. They're always trying to get out of jury duty. So who's left in that jury box? Employees. So what do employees look at in a wrongful termination case? Here's an employee saying, this is the reason why I fired him. The jury is going to look at it like, you know what? If they fired the guy, they should have given the guy a written warning. If they didn't do that, how would the guy know that there was an issue? And this business about verbal warnings, you guys have all heard me say verbal warnings, I don't want to say a complete waste of time, but they need to be documented if you give them. Document them. All right? So what do juries think? Hey, if he was warned, that's problematic. What about how do the juries feel when the person wasn't warned? If they weren't warned, it's a problem. If they were warned, the jury could look at it very easily and say, you know what? The person was warned, they were on notice, and you've got more of a chance of getting a favorable verdict from that jury or other trier of fact, as they say. All right. Okay. Consistency. Here we go with that word. Are similar disciplinary problems handled similarly to the one that may be presented at that moment with this other employee? You always got to be consistent. I've told you that. Documentation. You have to point out in the written warning the violation, as well as what they knew to correct the issue, as well as them understanding if they fail to correct the issue, that they could be subject to further disciplinary action up to and including termination. That's how it worked. Now, there's another issue about the rationale of the documentation. Was the employee given a reason for the decision, and was it the real reason? Don't fabricate the real reason. You've got to give them the real reason why. Just because you want to avoid any conflict with this person, you turn around and say it's a layoff when you know it's not a layoff. If something happens and it litigates, think about how that's going to look. Here you told them one thing when this was the real reason. That makes your credibility just go straight downhill. So be honest with them in terms of throughout the process with the documentation, whether the documentation is in the form of a written warning or whether the documentation is in the form of a performance review or a performance improvement plan. You've got to be honest with them. All right. Well, anyway, those are the golden rules, as they say. So use that any way you want. The biggest thing is document. All right. With that last comment, it's time to close out this segment. You can also let me remind you can also hear us on Facebook at Listen Up, or you can subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday, roughly from 9:45 to 10:15, 10:30 or so. And you can call us at 855-4J-POTS or 457-6887. Or you can email us at listenup@jameswilliampottsllc.com. Okay, I'm Jim Potts. I will continue to fight the fight. See you next time, and thanks for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.